think even with a gathering of lawyers in Dubai, it probably is now about time to stop. May I, frightful noise, can I start by welcoming all of you, Your Excellencies, ladies and gentlemen, to what is the second lecture in the Difc Courts 2013 series. We're delighted to see so many of you here this evening, and I'm encouraged to think are an indication of interest in the subject that we've chosen for discussion. The subject for discussion, as you will have seen from the billing, is civil and common law, conflict or harmony. I should say at once that we don't expect the discussion to focus on the substantive provisions of the law in civil jurisdictions or of the common law. This is not intended to be an exercise in comparative law in the strict sense. We could, for example, easily spend time in comparing the provisions of the UAE Civil Code in relation to the contractual obligations under the Difc law of contract. But that isn't the purpose of this evening. And since it is actually what I've been doing for most of the day already, I'm quite glad that it's not. Particularly as I see two of those with whom I have been doing it here today. Rather, the principal purpose of this evening is to examine the differences in practice and procedure between the two systems of court-based dispute resolution, the civil law system as applied in the Dubai courts, and the common law system as applied in the Difc court. I'd say at once and emphasize that the purpose is not at all to reach conclusions that one system is, quotes, better than the other system, whatever meaning may be given to that concept. Each system provides a means for resolving disputes between those who seek the assistance of the courts in doing so. Matters which concern those who do seek the assistance of the courts are likely to include the following. How long will it take? How much will it cost? With what degree of certainty can the outcome be predicted? How confident can I be that all relevant material will be before the court before it reaches a decision? What are my avenues of appeal if I don't like that decision? This evening provides an opportunity to examine the strengths and weaknesses of each system against those criteria and against other criteria which the panel and the audience may wish to raise. That brings me to the obvious point by way of introduction, that although this is billed as the second lecture in the 2013 series, it is of course not a lecture in the conventional sense. You will see at once that there aren't any visual aids without which no lecture could possibly be complete nowadays. Rather, it's a panel discussion. That is to say, it's a discussion between members of the panel, whom I'm about to introduce, and between members of the panel and the audience. It's a striking feature of tonight's panel, and one which perhaps reflects the structure of the legal system in the Emirate of Dubai, with the Dubai courts based on the civil law and the DIFC court based on the common law, that each member of the panel, and I'm not a member of the panel, has direct experience of working in both civil law and common law courts. I won't claim that that common experience which the panel members bring to this discussion is unique, but I will claim that it provides an opportunity for informed discussion which is rarely found and from which I've no doubt that we will all benefit. I'd like then to begin by introducing the panel members individually. When I've done that, I should invite each member of the panel to make a short presentation identifying some feature of the two systems which, in their experience, has given rise to interesting differences in approach. And when we've done that, then there will be a discussion which all of you will be invited to join. May I first introduce His Excellency Dr. Ali Al-Imam, who is immediately on my right and will be known to many of you as President of the Court of Cassation, or the Supreme Court here. Judge Dr. Ali Ibrahim Al-Imam began his distinguished career in the Sudan judiciary back in 1963. I might say, Dr. Imam, about the same time as I began mine. So it was obviously quite a good, my career, quite a good year. He was appointed to the Court of Appeal and elevated to the Supreme Court in Sudan in 1984. And in 1985 he was appointed President of the Sudan Court of Appeal. He came to Dubai in 1988 on secondment as a judge in the Emirates Court of Cassation, and in 2010 he was appointed President of that court, which is his current role. He's a member of Dubai's Supreme Judicial Council. He has an LLB from the University of Khartoum, as well as an MCL and an LLM with the highest honors from George Washington University and the United States of America. And we're extremely fortunate and very glad to have you with us tonight. On my left is His Excellency Dr. Ali Al-Madani, a judge of the DIFC courts. Judge Ali Al-Madani became a judge of these courts in 2008 and has become since a judge of our Court of Appeal. He's a member of the Joint Committee of the Dubai Courts and the DIFC Courts, and also of the UAE Judicial Sector Strategic Planning Team. Earlier in his career, he was a Dubai public prosecutor and then a judge in the Dubai courts, where he heard major criminal, commercial and civil cases. In 2004, he joined the DFSA and served on the committee which established the DIFC courts. He has a master's degree in international and comparative commercial law from London's School of African and Oriental Studies. He's my local, if I may describe him such. The third member of the panel on my right is Dr. Habib Al-Mullah, who will be well known to most of you. He's founder and executive chairman of the firm which bears his name, and he's drafted many of Dubai's modern legislative structures. He's also vice chairman of the board of trustees for the Dubai International Arbitration Centre, Difc, and chairman of the Chartered Institute of Arbitrators UAE Committee. Dr. Habib is a former member of the UAE Federal National Council. He was architect of the legal framework which established the DIFC and has served as chairman of the DFSA Legislative Committee and the UAE Jurists Association. And he's been in charge of training judges and prosecutors in Dubai. His many publications include an autobiography, Life's Harvest. He holds an LLB in Sharia and law from the UAE University, a Master of Law from Harvard Law School, and a PhD from Cambridge. We welcome him as a most distinguished contributor to this panel, and many of you will have read perhaps his article in the newspaper this morning, yesterday. The fourth member of the panel is Nicholas Say. On my left, he's co-chair of Brown Rudnick's International Disputes team, which includes Arabic, English, French, German and Russian speakers, and both civil and common law specialists. An experienced advocate who's worked extensively in the MENA region, and a duly qualified English barrister and French avocat. He has experience in trying cases in France, Qatar and other civil law jurisdictions, and offshore jurisdictions such as Bermuda, the BVI, Cayman, Jersey and the DIFC courts. He's active for governments, multinationals and major corporates, banks and financial institutions. He read modern languages at Oxford and did postgraduate work at the École Normale Supérieure and the Maîtrise at the Sorbonne. An extensive practical experience on the ground, and I shall begin by asking Mr. Say if, based on his practice in English and DIFC courts and the French civil law system on the other, he can give an example of differences between the two systems which he has found important and striking.
I think probably, Sir John, the most striking difference that I've experienced was when, as a young common law trained English barrister, after about 5 years in practice in the English bar, I decided to sort of pack my courage in a suitcase and move off to Paris to practice still English law from abroad as a barrister, but also to become an avocat in France. And of course, I went off to France with all my common law barristerial notions, particularly English notions, of my overriding duty to court, the fact that it would be quite impossible, for example, if a client had a document that they didn't want to show to the court that I knew of its existence, it would be quite impossible for me to mislead the court in respect of my knowledge of its existence. So I crossed the channel, I arrived on the side, and pretty soon into practice in France, I learned, as I was preparing for my French master, that in France they have a notion of what you would call in English professional secrecy, I suppose, if you translate it, what the French call secret professionnel, which is the ultimate and overriding duty of the French avocat. So you don't have the overriding duty to the court, you have an overriding duty to your client. And the French bar rules are very clear about that. They say that it's absolute and unlimited in terms of time. So in France, the confidentiality, if a client says to me, this document is terribly confidential, it's secret, I'm giving it to you as my avocat, you're in front of the Tribunal de Grande Instance or the Tribunal de Grande Instance, and I'm telling you that you won't be producing this document, then your obligation is not to produce it. Now that, for me, I think is a relatively striking difference between the French system and the English system, the French system being an example of the civil system. And just to move for a moment to perhaps matters local and the UAE system, I believe that there is the federal law number 23 of 92, which is the lawyers' law. Article 42 of that provides something which is, I suppose, akin to the idea of professional secrecy or confidentiality from what I might call a French perspective, because I know that UAE law is derived a long way back from Egyptian law and then French law. But there is at least a caveat in Article 42 of law number 23. I'm sure Judge Ali will correct me if I'm wrong, but the caveat is that you may disclose something which has been confided to you in secrecy or confidentiality by a client in circumstances where disclosing that fact or document would prevent a crime. So I think that there is a bit of an ethical minefield that I have to deal with quite regularly as being someone who is both a French avocat practicing in France and across the world in French law, but also as an English barrister practicing in many common law jurisdictions.
Thank you. Those of you who've practiced throughout the common law system will be well aware that even under that system there are different obligations in relation to disclosure, and perhaps we can explore those with the civil practice in mind in the course of our discussion. May I now turn to Dr. Habib and invite you, Dr. Habib, to identify any problems that you have found of particular importance or distinction between the two systems.
From my own perspective as a practicing lawyer, I think one of the main differences between the two systems is the whole concept of a hearing. And we realize this when we communicate with cross-border clients or international clients. For example, when we inform a client that we have attended a hearing and it has been postponed for another hearing, this whole concept becomes suspicious. Why the hearing was postponed? Why nothing has been decided? Why it was a very only 2 or 3 minutes hearing? Is it the fault of the lawyers, or is it the fault of the judges? What was wrong? While under common law, when you conclude the proceedings into a hearing, it's a full-fledged hearing. The parties come ready, the judges are ready, and normally what follows a hearing is the issuance of a judgment, not another hearing, and a continuous, endless number of hearings. This is one of the main distinctions between the two systems, and what results out of this difference is that the level of advocacy which is required and the preparation which is required for a hearing in civil law system, at least in the Arab world, there is very little, if any, preparation for a hearing, and almost no advocacy. Basically, you attend, it's heavily relied on documentary evidence, you submit your memo, and that's it. While if it's a common law and equally international arbitration, there is a full preparation for the hearing, and there is a lot of advocacy, cross-examination, calling of witnesses which happens during that hearing. So that's what I see as a difference between the two systems.
First of all, I would like to say that though there are some sort of differences, yet I believe that it's not to that great extent. Another thing is that every system has its advantages and disadvantages. The common law has merits and demerits, and so is the civil system. I experienced in both systems. I believe that none of them is better than the other. They are both equally good, and you can apply each of them to reach to justice. This is one thing. Then, as to the difference between the two, there are two major differences concerning the court of first instance or the trial court, and those concerning the Supreme Court or say the Court of Cassation, Supreme Court, and similar superior courts. As for the Court of first instance, the most important point of difference is that in the common law you determine issues. You make certain issues as to the hearing. In the civil system, there is no determination of issues. Each party speaks as he writes as he writes, and then there is no map for the court to go through it. But in the common law system, you make determination for the issues in difference between the two parties. There is a variance between the ideas between the two parties. One affirms certain point, the other denies it. That is the point of difference between the two. That is an issue. Whether it is an issue concerning law or facts, then the court has to decide on this issue. Another issue concerning another point, then after you gather the whole point in difference, you make the admissions, then you have to have the first hearing. In the first hearing, you decide the number of issues which have to be determined by the court, upon which you have to bring evidence. So you don't need to bring evidence on matters which have been admitted. Or even if the case is already admitted, then you have consent decree. This way will make it easier for the court and for the advocates and for the parties to reach to a solution easily and quickly. This is not the same way in the civil system. In the civil system, you just take your claim, and then the court, it's up to the court to decide whether to hear or not to hear. It's not a matter of right for the parties to be heard. The court decides whether to hear or not, or just to deliver judgment according to the presented or the papers brought for it, the documents, the statements made, and that's that. There another point of difference. Civil system relies heavily on expert evidence. Common law not the same way. They rely on expert evidence, but not so heavily like the civil system. And this also prolongs the period for hearing. Maybe other points of differences, but let us discuss them while we are making further discussions. As for the writing of the judgment in the Supreme Court. In the Supreme Court, according to the civil code, because it is based on codified laws, so its main source is statutory law, statutes. They don't rely heavily on decisional law, on stare decisis, on cases. On the contrary, in the common law, you rely on the decisions of the courts. The main source is the decision of law. Though now both systems rely on statutory law as well as decision of law, but the common law relies heavily on decision of law, on statutes, and that is that. In the civil system, you rely on statutes, codified law, textbooks, treatises. That makes some difference to some extent. So this is one of the points of difference. The court of cassation in the civil system does not consider itself one of the degrees low degrees of litigation. You litigate before the Court of First Instance and second the Court of Appeal. In the Court of Cassation, you just make law. You just see whether the lower court applied the law correctly or not, and that is that. So you cannot bring before the Court of Cassation more evidence, more documents, and something like that. This you can do it in the court, in the common law system, because the court considers it as one of the degrees of litigation. The Court of Cassation does not consider, when it handles the case, it considers the parties before it, the judgment of the lower courts, not the adversaries. The adversaries are not parts, the litigants are not adversaries before the Court of Cassation. The litigant before it is the judgment laid down by the Court of Appeal. This makes a great difference. In the common law system, of course, the adversaries are the litigants before the Supreme Court. This is also a point of difference. So, what results from this is that the Court of Cassation does not interfere as regards the quantum of damages. Damages will be assessed by the lower courts. It does not interfere at the quantum of damages, how they are being quantified, except in very, very exceptional cases, and for very minor reasons. On the contrary, the House of Lords can interfere as concerns the quantum of damages, and sometimes, in so many cases, they say that this quantity of these damages are very high, as high as that, good gracious me, we have to lower them, or we have to raise the amount. This does not happen in the Court of Cassation. Also, as concerns criminal law, the Court of Cassation does not interfere with the assessment of the penalty if it is within the range, the maximum and the lower range. It cannot interfere. It does not interfere. In the common law system, the court can interfere and can alter it, change it, add more, less, and so on and so on and so on and so forth.
Thank you very much. We have served together and sat together in these courts. But you have the bring the experience of having sat also as a judge in the Dubai courts. What contribution would you like to make?
I was saying it's a really difficult job to be a judge, even at this stage. But yeah, I always believe that. I mean, it's really a tough job to be responsible for deciding people's rights and destiny. Especially if you're involved maybe in the criminal system. I mean, maybe one small example would indicate how tough is this job. If you just hear someone's case, today it's a criminal case, he's in jail, his imprisonment, and then he deliver his submission and everything, and then ask you to deliver a judgment. You've been very busy, and then you said judgment is reserved. 1 month, 3 months, 2 months later, you decided he's not guilty. I think if you look back and think what he was doing in the jail while you were busy doing something else, I think it's tough. And that's what I remember that led me to think judges should try being in prison for some time to feel how others really could suffer because of their business. I mean, this one example that which reflects how tough is judging life, and again, people's rights and destinies in his hand. It was really tough. It's even tougher when you have so many cases, when you have thousands of cases to deal with very early. There is so many judgments to write that even tougher. I would like to say again, I'm in a much better position now with the DFC court. I'm luckier because I have less number of cases, but still, I mean, hard job to do. Then the conversion from the civil to the common law is another difficulties and a great challenge that I faced during my career or during even my life. Once I joined the DRC, first of all as a judicial officer before I wanted to judge, because the system does not appoint fresh graduate or fresh judges. So I got to do sort of conversion course, studies, training, sort of that, which took me around 4 years to be able to get a position of a judge and sit at the CFI level. Again, I'm really lucky here because I have much less number of cases, so I have more time to do research, to write judgment, and to take care of people rights and people's application. I think the challenge is even greater when you have another difficulty, not just converting to another legal system or judiciary, but when you have another, for example, language problems. My mother tongue is Arabic, and I really suffer to be at this level of English to deal with people cases. I'm still learning. It's also even the other challenges that is the cultural, the full understanding, the full concept of the common law and the principle of equity, principle surrounding the whole common law. I don't think it's an easy thing to get. I don't think it's in a short time you can cover the whole principles of the common law, because it's very, very, very wide ocean even. And I'm sure if you ask even Sir John Chadwick with his extensive experience, he will tell you I'm still learning. So yeah, I'm still learning too. I've seen so many differences between the two systems. I've seen differences related to the service of the claim, differences related to case management, cross-examining, production, discovery, so many things, cost, discovery, even enforcement. But the most striking point maybe for me, and I would like really to share with you, and I feel or I believe it's of importance to me and to share with you, especially there is as well local lawyers, Arab lawyers who are thinking, or even civil law lawyers who think to convert to be a common law lawyer to some extent and to appear before maybe me or my friends to join in our court, is that the role of lawyer in our court. Let me tell you how active the common law lawyers or the lawyers qualified to appear before our court. And I will refer it now to as a system. I'm not criticizing the local system. I'm not saying why the civil law lawyers, it's like that. I think it's all about arrangement in the law, arrangement in the procedures, arrangements during the training, during the career, and a lot of things involved. But I think one of the most important really differences, how active are the common law lawyers before their court or before the common law court. I can give you sort of examples like they involve in serving the claim, which doesn't happen in the civil law court. So the court relies on them to act as a court officers, and that's a great service for the court. They prepare the case during the case management. They prepare the case file. They give the judge his copy of the file. They give the other party copy of the file. And gathering the case, preparing the case, preparing the file isn't simple. It's involved a lot of things. Especially we've seen bundles involve thousands of papers and evidence. You keep in your hand the evidence of your opponent, and we still believe in you. You're preparing the case in a survey, case that involve interest, submissions, and a lot of things related to your opponent, to your or defending or claiming party, and we still believe in you. And then the most important role that the lawyers do in litigating before the judge and making judge lives to some extent easy by explaining the law, referring to the right references of law, precedents, involving cross-examining, preparing, a lot of evidence, putting a very clear and good submission before the judge. I would say that the common law lawyers, maybe they're trained to do this, and the system, the procedures allow them to be as active as we could have seen. And I think this is which I can call it an advantage, which builds advocacy. and could prepare a lot of good lawyers to be good judges in the system. So as its advantage in the common law system is its sort of disadvantage in the civil law system. And I do not refer it to the locals themselves. I don't think the local lawyers or the civil law lawyers got hand in this. It's not their responsibility for not being active. I think the system is not prepared to get them active or allow them to be more active. Now, I don't think even the civil law judges' mentality is built to allow lawyers to be as active as that in the common law. I don't want to be long, but let me share this with you. I remember and then the other question I asked him, who is responsible of managing the justice? I think it's the judge. It's the judge, it's the court, or it's the system. Responsibility to allow the advocacy to present their cases fairly. I believe in the principles that says, and I think it was said by one Arabic-American philosopher, Gibran, when he says, there is two main factors for justice to be done. First, a fair presentation. Second things, someone has to listen to it carefully. And without these two elements, I don't think we could conclude justice. Sorry for being perfect. Thank you.
Thank you. These documents, whether they were before or against you. Those of you who practice in the DIFC court here will know that we've gone more towards the arbitration system. You start by disclosing documents on which you rely, and you don't have to disclose documents on which you don't rely. You're not likely to disclose documents which harm you because you aren't going to be relying on them. There is then, of course, provision for orders for special discovery, and they come out. Any judge and any litigant is likely to think that he's going to get a fairer result if he has more information about the issue than less. And I would like to invite Dr. Habib Al-Mullah just to explain what the discovery process is in the civil court. How far do you have to produce documents? And how far does the absence of an obligation to produce documents affect the outcome at the end of the day? Okay. Here we'll know that we've gone more towards the arbitration system. You start by disclosing documents on which you rely. And you don't have to disclose documents on which you don't rely. You're not likely to disclose documents which harm you because you aren't going to be relying on them. There is then, of course, provision for orders for special discovery, and they come out. Any judge and any litigant is likely to think that he's going to get a fairer result if he has more information about the issue than less. And I would like to invite Dr. Habib Al-Mullah just to explain what the discovery process is in the civil court. How far do you have to produce documents? And how far does the absence of an obligation to produce documents affect the outcome at the end of the day? Okay.
Well, I can talk only about the procedure before you leave courts. That's my area of expertise. Well, there are pros and cons for both systems, whether you want to go for a wide type of discovery or producing of documents or a more limited scope, which is the method that UAE courts adopt. Under the UAE courts, the obligation to produce or reverse the right to request for a document is limited to documents where the parties rely upon and documents which are common between the two parties litigating before a court. So there is no room to ask the parties or seek the court's permission for a wide type of discovery. or even a limited scope of discovery. Now, this is good because to some extent parties focus on their case. It's less burdensome, it's more cost effective, but it comes with a price. The price is that the court is not able to see the whole picture. And in many cases, this limited scope of seeking documents, requesting documents, whatever you may want to call it, lead to judgments being wrong due to the facts not being fully presented before court or tribunal. On the other hand, if you go to a full discovery process like the US courts, then of course you have the costs involved, you have it sometimes becomes a fishing expedition. So we need to strike some balance between these two systems.
Interrogatory or production of documents or whatever it might be, usually, often, or let us say occasionally, it has been used as a means of dialectic tactics, whether in the civil system or in the common law system. It has been used as a dialectic tactic. When an advocate believes that his case is total loss, he prolongs time by asking more interrogatories, by asking for more documents, more statements, and so on and so forth for a long time, just to buy time. This is practiced in both systems, not in this way.
Well, I'd like to invite contributions from the audience on that question. How far are we getting the balance right in the system, in the two systems? As Dr. Habib has explained, there is a balance to be struck and a price to be paid. Less discovery, quicker, cheaper, and you end up much of the time with the same answer. Sometimes there is that smoking gun document lurking away. When you found it, it may alter the whole of the case. Can I invite observations, comments, experiences from the hall? Anybody found this problem or affiliation? And then make a comment.
My name is Alain Zahlandikayeti. I'm a French lawyer, basically, member of the Bar of Paris and based in Dubai. I've experienced both systems, and I suggest that we make a difference between the law and the court system. Concerning the law, I think it's a question of habit or custom or culture, basically. I don't think that there is a law that offers better protection than another law, and I think it's a question of getting used to a law more than to another law. So it's a question of culture. Concerning the legal system and dispute and court system, I think we need to get back to the principles of a court system which is the contradictory. Both parties need to express themselves. Under the French system, at least, a party who claims for a fact needs to prove it. So why does this party have to prove something else or provide evidence for something else than what it is stating? That's the reason why in France they will never understand what a disclosure system is. Both systems are very long. Both systems are ruled by generally unspecialized judges. And today in the business, as we know, we have very specialized issues involving environment, IP, high-tech, clean-tech issues, and most ordinary courts are not specialized with that. So basically we have judgments which are really I'm going to be polite on that, so incoherent judgments. Therefore, we have really a good practice to push our clients to arbitration. At the end of the day, Perhaps arbitration is probably costs the same thing than a court long process and long hearings and attorneys and all what you have. So therefore, I would like to ask, if you don't mind, on every one of you, if you have the choice, which law would you recommend to your clients, if you have one in mind? Is it which system of law, whether civil or common law, would you recommend for your clients? And if you have the choice, which system you would recommend to settle disputes arising from the contract? Thank you.
I'm also going to remember the fact that Alan said that if you've got a French client, or you're in France, or working under French law, they're going to expect to produce only the documents they want to produce. Well, arbitration today, I think that falls outside the parameters of the likely game, at least in terms of international arbitration, perhaps not in terms of domestic French arbitration. But if you're in international arbitration, the likelihood is that your arbitrators, even if they're sitting in Paris and let's say it's a three-man tribunal and three-man, three-woman tribunal, all three of the members are French, they're likely to apply the IBA rules of evidence. And if they do that, they're going to allow document production. And if they do that, they're going to allow document production in two stages: request for documents, production of documents upon which you rely, and then request for documents. And funnily enough, arbitration has begun to influence the court system, because you've seen the Difc courts have, to some extent, enacted the IBA rules principles within their main frame of rules for disclosure of documents or document production. And now, if you look at England, England has now sort of updated and rejuvenated its civil procedural rules so that judges have a wide range of choices, ranging from ordering full standard disclosure, producing all relevant documents, to having a two-stage process like the Difc courts or arbitration, where you produce what you want to produce first of all, and then respond to requests to produce later, and perhaps produce those smoking gun documents if ordered to, depending upon your professional ethics problems. And then the English courts also have the possibility to do away with disclosure completely in a given case nowadays. So I think that things are changing, and you don't necessarily see the great differences between arbitration and the modern practice of some commercial courts that you used to. In terms of your question on the law, I'm afraid that's an impossible question to give a fixed answer to, I think. It's going to depend upon a particular set of circumstances you've got as to whether you want to choose, as to what law you want to choose to be the applicable substantive law of your contract. You might make other choices in terms of where you seat your dispute.
It's also a question of which shouldn't arise in this emirate, because if you look at the legislation, you should find that the legislation directs you exclusively either to the Difc court or to the Dubai courts, and you shouldn't ever find yourself in a position where you do have a choice. Apart from the odds, if you do have choices, an inherent danger that you might get a different result in a different court. But the practice in the protocol here is that you should find that there is one court for your dispute, and that's where you've got to go. Of course, there's a choice between courts and arbitration, but all sorts of other factors come into that. Could I just ask, is there anybody here who has had the experience of having a document which they haven't been asked to disclose, which they know would have altered the case in favour of the other side? Any of you? Well, who, having pressed for some disclosure from the other side, have unearthed that golden nugget which you believed was there, which has altered the case in your favour. I just thought you all put your hands up for that. Yes, they would.
My name is Diana Hamadi. I am a lawyer with right of audience before the UAE courts and Dubai, where I appear almost daily before the courts. Court of First Instance, Court of Appeal, and I have lately been certified licensed before the Court of Cassation. I'm not standing here in defense of the civil courts where I practice. I'm just saying that the undermining of the advocate's role in the civil courts is not said in a justified manner. I would like to share here what we do as lawyers, at least in the discovery part, where the common law is kind of more active, more pressing on the parties. However, I can say that the advocate's role before the civil courts is more active because it depends on how much you know of what documents have to be produced representing your client, and the litigants are more engaged in that process, more than what you voluntarily would submit to the court, or the next step where the request would come. So maybe we start by requesting each other documents, and we make it clear to the court that there has been a document that is not submitted to the court and may make a difference in the judgment. Now the other party may say, of course, that they would deny the possession of this document. But mainly from my experience before Dubai courts, I would go to certain authorities that I know would have a copy of this document, and the court would allow me to contact. The court would directly make the courts would directly make the contact with the authority to produce such document. So I don't see the role of the lawyers, of the advocates before the civil courts in any way less than what the common law lawyers do. It's mainly that we don't have, as Judge Madani made it clear, we don't have the right to argue before the commercial, the civil courts. I do argue before the family court, for instance. We do argue before the criminal court. But I guess when you come to Dubai courts, civil courts or commercial courts, and you see the number of files before the judge, you would understand why he wouldn't want to give everyone enough time to talk. And I honestly would understand. Now, the choice as a lawyer, I would like always to think that I'm doing the best for my client. I am bound by a duty to my client. I believe in it heartily. I think just because I'm a civil lawyer court, I think of the justice system, I think of the court, I think of my duty before the court, but my client is my first priority. And this is what I've learned as a lawyer. So as a client, I would like to direct my client to the best options in the UAE. I would say, I don't have enough experience, I could say, before the Difc courts as a common law court. But I would say that what we know of Dubai, of the laws that are applicable in Dubai, I would still very much trust the court system here, what is applicable, what is enforceable. Arbitration is an amazing alternative for dispute resolution, but I wouldn't yet convince or just try to get my clients to go to arbitration because of the fact that they would have to go back to Dubai courts, which is expensive for validation of their arbitral awards. So to me, so far, I would still very much be convinced that the best choice for my clients would be Dubai courts, where I practice until now. So I hope that was...
Well, thank you. Can I broaden the discussion from documents to the role of the advocate? It's a matter on which you touched, the President has touched on it. There are two features of the common law system which I think would strike a civil lawyer as very odd. The first system is the duty on the advocate to draw the court's attention to any point of law which is relevant to deciding the facts, more so in the common law system where we rely on precedent, and so a lawyer who knows that there's precedent against him is, or relevant, is obliged to disclose it. I can't help thinking that many clients will say, well, I'm not paying you to find the cases which don't help me. I'm paying you quite enough to find ones that do. The second point, which I think would strike anyone who came into court in this building, perhaps particularly a court in which I was sitting there, I said, there is a very considerable dialogue between the judge and counsel, because you can refine what the point is and refine the argument through dialogue. And I would be interested to hear the President's view on that, as to how far the court is helped or not helped by having a dialogue between the bench and counsel, and not just looking at the written brief.
To my mind, he is allowed, after making his after bringing his documents, and after the first hearing, all to contribute in determining the issue upon which the court can hear the case, the whole case. In the civil system, he has no such a case. After documents have been brought for the court, everything is brought, then it's up to the court to decide whether to hear the case, to allow advocates to bring witnesses to be here or not. This, of course, makes some difference. Because in the common law, he has a better chance, I think, to bring his own witnesses to be here. This is better for the advocate. But anyway, at the end, it is a matter of justice. Because if it's a case which relies only on documents, even if you bring witnesses, they will say they may add nothing more than what is written in the documents. And the judge may be convinced that the documents are enough for him to deliver his judgment.
Well, let me ask Dr. Habiba, do you welcome a dialogue between the court and the advocate, in the course of which you can identify what it is that's bothering the court and seek to meet it? Or do you actually prefer a judge who says nothing from beginning to end, except perhaps good morning in the morning and good night in the evening? I have appeared as such a judge in Hong Kong, actually. It was scary. You had no idea from the beginning of the day to the end whether what you would say was making any impression or not. The answer I might say is not, as I discovered again. It was pretty scary. Do you welcome a degree of dialogue between the court and the advocate, and do you get it in a civil law court?
I think there are two issues that you have raised. I'll start with the latter one because it's the easier one. Do you get it in courts? Rarely, yes. Seldom. I mean, yesterday I was before a court and I was pleading, and the judge told me, when you finish, I want to see you. Right? After the hearings, and it was a major criminal case, and he said, there is a document which has these characteristics. It's a very important document for us. We know that it exists. We have searched the file. It's not there. So please bring it to us. Now, this kind of dialogue, I think, is helpful because it's obvious that the judges are trying to reach to a certain conclusion. They want to rely on a document. For some reason, they can't find it. So they seek the assistance of the advocates. The risky part on this are two-folds. One is client-attorney privilege. To what extent can an attorney engage in discussion with a judge without risking that privilege? The other point, and that's maybe more particular to this part of one, is that when you have advocates trying to prove a point, trying to defeat each other, if the court starts to get engaged into a dialogue, one of the advocates can easily say, well, the judge has disclosed his opinion, so that disqualifies him, and uses that, whether it's rightfully or wrongly, as an excuse to try to hinder the whole process. So again, it's not an easy balance to strike. What would help is that if there is clear legal statutory guidelines to direct the courts and the parties as to what is allowed, what is not allowed. That is something that we miss here. It's not available under our current legal system.
Well, I do agree with Hamid that procedures in the common law, it's even more advanced. And I think, but it's not all of the common law system, maybe. I think what helps the countries who apply the common law now to be much advanced when it comes to the production of documentary discovery is the case management. I believe if I'm a judge, hearing the case today, in my mind I'm going to reserve it for judgment, and then suddenly that lawyer can apply for me and say, oh, I believe there is a document exists in the other party, or we would like him to submit, and I would like the court to order him to submit it. That would be considered to be a nightmare for the judge, and that would be another reason why he should respond to it. That there is a case management, there is case management time, so the judge, lawyers, people would know. Case management time, everyone knows that this time it's for parties to prepare the case, it's to prepare to bring any evidence they wish, or to apply to the court to tell the other party to submit any valuable or important document or evidence they believe it's in his hands. And the judge will respond to it because he knew that it's party's right. It's not going to, influence the hearing time or going to cause any sort of delay. And the judges, through this case management, would be powered also with a lot of authorities to read, to understand, to test how relevant that document, how important that document is, and to compare the application with the defense or with the reference of law. So the judge won't see it as a big burden or something that's delayed. So I think case management is a great deal, I think, and helpful for the court, for parties, that to take this point in a very professional and efficient way, I believe.
I think a short answer to the question is that in both systems, an advocate has the right to plead before, whether civil court or common law court. He has the right to plead, and he can make any pleading, a kind of pleading, finding discoveries, taking points, or anything in the presence of his other colleague. There is no problem about that. In any court, whether being court, common law court, or civil law court, there is no problem about that, I think.
My name is Makawi Al-Makawi. I'm a practicing lawyer in Dubai, ethics jurist firm. I just want to mention at the beginning that I am a common lawyer by education and by early practice. And I came to UAE, 3 decades ago. The only thing that made me survive practicing civil law is because in my education and my early practice, it has always been said to me, you are educated not to memorize law, but to think legally. To think legally. That's the only thing that made me survive practicing civil law. However, what I want to pick today is a point raised by His Excellency Dr. Ali on that the civil courts heavily depend on expert reports. I think this is one of the things that strikes me as creating real problem in dispute resolutions. Experts here are selected randomly by alphabetical order. And in most cases, when they say referring to an expert, that expert could be an auditor, but the case can be a maritime case. So you end with the expert just looking into the figures, not understanding anything about matter. And it could be other disciplines of practice in law. What happens is that when the expert submits his report to the court, and then you ask the court, can we call the expert for discussion? Never. Very, very seldom the court would accept that. You say that this is an expert for the court. Either we take his report, part of it, all of it, or just throw it away. So as a party to the case, I don't have even the chance to discuss or question the expert ability, whether he is an expert or not. I had the experience to appear as an expert before British courts in Europe. And believe me, it's the worst nightmare for an expert to stand before a judge and 7 or 6 lawyers from both parties trying to tear you apart. I stood for 4 solid hours answering questions to the extent that the judge called somebody to bring me a chair and water. So this is how, when the matter is dependent on an expert, then people have to be quite fair to give the chance to the parties to consider what the expert has done. Thank you.
Well, I can share with you the experience of being an expert. I was once an expert witness in the court in an American court in New Orleans. The first question that was put to me was this: well, Mr. Chadwick, how much should we be paid for all this rubbish? So I always feel a little cautious here. But that opens up a topic which I would like to hear the panel's views on, and that is cross-examination. Because you were indicating you felt at a disadvantage because you couldn't ask the expert the questions that you wanted in order to clarify his views and perhaps whether he really understood what the problem was. My understanding is that cross-examination is either very limited or non-existent in a civil court, except perhaps by the judge. Nicholas, would you like to tell us about that?
Certainly. What I can speak of particularly, I suppose, is the French system, and I have seen some action in other civil law jurisdictions. And it's fair to say that, for example, in the French system, if you have a commercial case which you take either before the Tribunal de Grande Instance or the Tribunal de Commerce at first instance, it is likely to be very, very rare that a judge is going to deign to hear witness evidence or want to hear witness evidence. Proceedings tend to be based mainly upon written submissions and documents which are filed with those written submissions. It's even fairly rare for parties to introduce witness statements at all. So there is no, there's very little hearing time given over to cross-examination. If in an extraordinary case you do have a witness that comes in front of the court, then the likelihood is that it will be the judge who is going to ask the witness more questions in an inquisitorial kind of way, rather than it being each of the parties' advocates, which of course is a huge contrast with the common law system as we know it practiced whether in the DIFC courts or England or in various offshore jurisdictions.
Sorry, President, in your experience, is cross-examination a useful tool
More
in getting the right answer?
Definitely, cross-examination is more useful than just giving judgment on documents. If possible, to allow the parties to give their evidence, to bring their witnesses to be here, that is better. Besides, of course, besides the documents. Not to rely on the witness alone.
Well, going back to Dr. Makali's point, that I mean, being a judge in the civil law system, and I have friends, so many friends, lawyers friends with their local arts and even foreign, who got business with the Dubai court. And also, because I'm sitting in the strategic planning committee, the judiciary in UAE and in Dubai particularly, I think it's one of the biggest problems Dr. Makawi is raising just now, that first of all, the protection of the expert from being cross-examined by the court. I mean, let's put it this way. The law allows for party to ask for that witness to be examined. And the judge got the authority to allow that expert to be examined as a witness by parties to a very far extent. I think the only problem with that, in the practice, the judges tend not to allow lawyers to use that kind of right. They tend to, maybe they, I think the excuse is that the case load, the number of cases they have, but I don't think it's going to be an excuse because it's people right, it's people destiny. Every person, his case is the most important case for him. And I think the answer for that, Dr. Makawi, is the introduction of a better system of dealing with that system. I mean, I am the son of this local system, and I practice it. I'm not criticizing to that extent, but I'm criticizing the judges who should. The system is good. The law allows for that kind of privilege for lawyers or for the litigant to battle the experts and not to be the final judgment against any party. I think it's a very important time to give lawyers the right to just to question the expert's report. It's important also to judges. They should understand how lawyers, they should understand how lawyers suffer. Not just lawyers and their client, the party. They suffer from the reliance on witness, expert reports without allowing it to be tested in the hearing. And we've done sort of survey, and we heard from lawyers, we heard from litigant in person that this is a great disadvantage in the local system. And I'm sure not just Dr. Makawi, there is a lot of other lawyers in this room maybe will agree with him. And in the new proposal of the civil procedures law, there is sort of case management system that might allow parties to bring their own witnesses, or if the court would call for court-appointed experts to give more time, space of time, or even rights to bar to question that kind of where the hearing time should be located to the legal debate and discussion. It's not only that's a problem. I remember I even asked one of the judges, okay, you're complaining you have 65 and you have no time for everyone. Why you finish your hearing at 10:30? He said, no, it's practice. They start at 9 and they finish at 10:30. They're complaining, we got 65. Why don't you stay till 2 o'clock, 3, 4, 5, 6, 10 o'clock, 9? He said, no, we can't allow. As I said, case management would be a very good thing to help the judges, first of all, to give them the ability to hear, to listen to parties, to give again litigant. It's not necessary to be lawyers, even litigant persons, litigant person. And the final word I will say, during my time in the court as a judge there, I used to call it a nightmare if I see lawyers in a case. And nowadays, thanks God, it's a lawyer. If I don't see a lawyer, it's not even if I don't see a lawyer in a case, a lawyer that should help me present this party's right before me, referencing to fact, evidence, or matter of law precedent. And everybody wants to look at it as well, we need to be really active.
Good afternoon, everyone. My name is Ashraf Mutay of Mutay & Associates based in Dubai. I had the opportunity to study in Egypt initially, and then study and practice in Paris, and then the United States. I think the problem and the issue is not a difference between systems. I think the issue is the difference between culture and education of judges. The same civil judge in Paris, for instance, they allow many things that, unfortunately, in the same judge, perhaps in this part of the world, is not allowing the same. So I believe it's an issue of culture and education. And for instance, when we say that the civil system is depending heavily on experts, I don't think so. I think that basically it's the judge that is finding it easier to refer everything to an expert. At the end of the day, just take everything for granted and even don't allow parties to discuss anything in the expert's report. So I think that the issue is more of culture and education of practitioners and specifically judges in this part of the world versus Europe, for instance. Thank you.
I have to comment on this. I believe that I completely disagree with you. This is a matter of law, it's a matter of real provision. Whether being in Middle East or in England or in United States, he applies the provisions of the law. Cannot do that. This is not a matter of human interest or human rights. You have to apply the law, you have to apply the provisions as they are. A French judge cannot do anything more than apply the same provisions applied by the Egyptian judge.
Ishraq Abu Taha from International Law Firm in Zawi. I just want to add a different point of view. I am a court-appointed expert in intellectual property, and I am arbitrator in this country. I came from a common law background, and I worked here for the past 10 years. But I don't see that, first I agree with Dr. Ali Ibrahim al-Imam that there is no difference between the systems rather than the culture and the practice of lawyers, how they practice each system. And from the expert point of view, I do not see any points of having the expert to be re-examined or to be asked by the judge to come and to deliver his opinion, which is already in the report. So we have a very good practice in intellectual property area, where we have, we develop a system. This is up to each expert, of course. So we have a system where we can have the parties come to the expert, deliver their evidence fully, and they can also be examined and re-examined by expert. They can deliver their opinion, and also the law allows each party to have his objections and challenges, and then to return back the expert report to the expert, and then he will also, I think he can also give his feedback. I think opinions again is expert, it depends again on each expert and area of laws, and it should not be generalized. Thank you.
Can I just ask Dr. Abdullah, how far does the use of expert reports, in your experience, lead to cases really being decided by the experts rather than the judge? Is that a danger that you recognize?
I wish that the discussion not dwell into this topic. I have very strong views on the issue of experts. In 1993, the Chamber of Commerce invited a conference on the role of experts in foreign courts, and I did a survey on a number of cases that went to experts and how many of those cases were conquered by the courts. My own view is that this whole expert system has killed the judiciary. It has done significant injustice, not only to the parties, but to the lawyers and to the justice itself. And I think that's enough to say.
I think we can. There's a question at the back.
My name is Binoy Susi. I'm an Indian lawyer. I am practicing the arbitration law with my partner, Dr. Rakuban. My question is, sometimes in the application of arbitration clause in a contract, it will clash with the civil laws. For example, Article 6 of the UAE Commercial Agency Agreement, some penalty committee laws, they say that if there is any dispute regarding this matter, go to the committee, and the state court has jurisdiction. In such a situation, if both the parties agree that they can waive this, they agree for to waive this right and go to the arbitration clause and make an agreement, can this arbitration power rectified by courts?
You mean to say that if the parties made an agreement on arbitration, there is an arbitration clause?
Yes.
In all cases, in all times, and in all situations, it should be sent to the arbitration.
Right.
You mean to say
For this clause, the main UAE Commercial Law Agreement.
commercial agreement? I know.
And Article
But the one question, but one problem you have to face, that is the public order. If it's a great public order, you cannot do it. That is the problem. If it is not contrary to public policy, it will be sent to arbitration, but not otherwise.
This matter is relating to the committee, saying about committee.
What do you mean?
Committee means suppose there is a...
Anything concerning public policy being related to legislative guidelines or anything, if it comes to public policy, it will not be allowed. Not allowed. Definitely. And this is not in the local law, but even if you go to the federal, or if you go to the New York Convention or any other international convention, you will find that anything contravening to public policy is not allowed. Definitely.
That's a good question. All the parties agree that they waive this clause. All the parties, they have the right.
You want to arbitrate in spite of the question that it is contrary to public policy. Do you want to arbitrate?
No, not about public policy.
If it does not contravene the public policy, you can arbitrate, but not otherwise.
Well, yes, the question over here, then we'll take one or two more and wind it up.
I'm working with a Swedish company. I want to go back to the expert topics and agree with Dr. Habib al-Mullah. How the expert matter is unjustified in the civil law system. In the common law system, for example, litigants have the right to examine the expert and how much he is qualified for the matter of the dispute before he commences his job. But as there is precedents of Dubai Court of Cassation, Egyptian Court of Cassation, the expert does not require that the expert is specialized in the matter of dispute he is appointed to decide on. It's enough that this matter is linked to his job. For example, we see in the past 2 years many construction cases referred to employees with Dubai land departments. Those cases need a civil engineer or civil consultant, whatever, but the expert appointed in these cases was someone in the financial department in the Dubai land department or in administration department, and that's enough as per Dubai Court of Cassation precedent, because this task is linked to his job. He works in Dubai land department, so he can decide in construction matter whether there is a delay, there is no delay, construction performance, time on the contract. So I believe that this is one of the differences, that the advantage is for the common law than the civil.
I'm actually on Dr. Habib Muller's side of the experts. I think too much reliance is based on experts, even in the common law. I had an expert tell me the other day, everybody knows that the moon is made of green cheese. And I said, not me, I don't know. So I think you have to be quite cautious. Nicholas, have you had experience with it?
I have, and I suppose both in arbitration and I suppose civil law arbitrations, as well as common law arbitrations, common law courts, and civil law courts. I think I do find astonishing the idea that an expert should not be tested on whatever opinion they've given, and certainly if it's the case that experts are taking over to the cases where they are, to the extent where their views are unquestioned, and I think that is, a dangerous thing indeed for any proceeding. One of the things that has been seen, I suppose, particularly within international arbitration in the last few years, is the idea of hot tubbing and putting experts together, having them all in the room at the same time, and sometimes the panel of arbitrators asking them questions at the same time. And that's sometimes a disaster, but also sometimes works quite well. But I don't think it's particularly because I'm a common lawyer by original education and a civil lawyer latterly, that I think that it is very important that judges and tribunals hearing cases ask themselves questions about the probability and veracity of what is being told them by experts. I think that's a fundamental importance.
One of the differences between the common law system and the civil law system is the fact that precedents in the common law system bind the lower courts. To what extent this is applied in the civil law system, in the high court in particular?
I believe that now, right now, in the civil system, not only in Dubai, everywhere, Egypt, everywhere, they come to believe that the president should be binding to a political statement, or at least they should be privileged to the other sources of law. And in the Dubai court in particular, we are bound by our presidents. The same way as the common law system is bound by its presidents. We don't say they are only persuasive, we are saying that they are binding to us. But by binding, we say that binding in the sense that if they are correct. Sometimes, rarely, very rarely, a case may be disregarded, may be considered a case, taking case not well written. So we have to deviate from the principle laid down by that case. In this case, in Egypt, maybe in Paris or in any civil system, they have said in the common law, of course, they distinguish case from another case. They make it by distinction. They distinguish case from that case. But in the civil system, they constitute a tribunal of the whole court, the circuit of the court. Here we have five circuits. We take a number of judges from each circuit. We constitute a tribunal which reconsiders the principle, and then it may deviate from it. Otherwise, the principle will be binding and not only persuasive, binding and the court will follow. But if the whole committee changed its mind and laid down another principle, then we will follow the new principle. So, to a great extent, now they are similar. Because in England now, we are to define the law. For a century, we say that in England, there is no need for codification, only presidents, start. Now they are to define every kind of every aspect of the law in England, in the common law. In America, there is the American statement. in the civil system, now they rely on the president and they feel bound by him. Here is very surprising.
It is an important principle in achieving a degree of certainty. If lawyers are advising their clients what the outcome is likely to be,
And what is the most important wisdom of this is the stability of the law. You have the law to be stable. So you have to be bound by the president.
people really want to know what's going to happen, and they don't want a situation, usually, in which what happens depends on which judge happens to draw on the day. We have, as the President has mentioned, we've now moved, even in the United Kingdom, away from complete binding precedent, and the Supreme Court can depart from its previous decisions. But in the way that the President explained, they'd be very unlikely to do so without, first of all, having a full back, the full court's back, and secondly, being really quite convinced that it's wrong. And you need to have that. You need to have that safeguard. Otherwise, you get anomalies which everybody recognises becoming enshrined in the law. You can't really apply it without legislation, which is not efficient. Well, I think we should now draw it to a close. Thank you all very much for the contribution you've made, particularly those who expressed points of view which have not been by any means all on the same track and still engaged in debate. And may I, on your behalf particularly, thank the members of the panel, the President, Dr. Ali Al-Imam, Judge Excellency Judge Ali Al-Mani, Dr. Habib Al-Mullah, and Nicholas Say, for the contribution they made tonight and giving up their time to come along and make it. And we join in the usual way in saying thank you.